Good morning. It's time for another rambly video. We're going to look at a few things today. First, we have Alzheimer's Sucks, who thinks that we're not free. I don't particularly agree with arguing philosophy. Philosophy will get you nowhere, just period. The 13th Amendment outlaws slavery and involuntary servitude, except as a punishment for a crime. You are not a slave. You're not. That's the long and the short of it. Are you completely free? No, there are always limitations on freedom. Freedom is a relative term. If you and four other people go to a desert island and you all agree that you can't kill each other, and if somebody does kill somebody, then everybody else will punish the person who commits the murder as a collective, and they will agree, and you agree amongst yourselves that that would not be a crime to punish a person who's committed murder. All of a sudden you have an imposition on your freedom. If you agree, if you and the four other people go to the island and agree that you're going to divide the island up into fifths, and each person has sole control, complete sole control over their own fifth of the island, well, now you've just limited your freedom on the other 4/5 of the island. Freedom is a relative term. There is never 100% freedom. Even kings weren't free, if that's your definition of freedom. Because the kings had to do what the nobles demanded, because if they didn't, then the nobles would rise up against them. So your definition of free is useless. There is no one under your idea of freedom that is truly free. And ha ha ha, Merb thinks he owns property. Let's see how long you get to keep said property if you don't pay taxes on it. The way this works is you own the property. The government can control what you do on that property, just like the government can control what you do anywhere. You can't commit murder on your property. Does that mean you don't own the property? Again, if that's going to be your working definition of ownership, complete unfettered control over the use of that property, then no, you don't own anything. You can't use your shirt to strangle someone. Does that mean you don't own your shirt? It's a useless definition. If you've taken it down to that point, then there is no thing that you can own. You don't even own yourself at that, if you use that working definition. And as far as getting to keep the property if you don't pay taxes on it, if I get a judgment against you for whatever reason, like let's say I get a judgment against you because you damaged my property, and so I have to fix my property. I get a judgment against you. You decide not to pay. I can then file a lien or a levy on your property, depending on what kind of property it is. I may attach a wage garnishment of various amounts, and I do that through the government. Usually it'll involve recording it with a county recorder or sending a writ of execution to a sheriff, a county sheriff, or something along those lines. So the government would do it, but they'd be doing it on my behalf, just like the judge is the government, but the judge is adjudicating on, my behalf. So the government doesn't have the sole power to attach liens or levies or anything like that if you don't pay your taxes. And the government doesn't take your house per se if you don't pay your taxes. What the government will do is the government will go through the standard channels. They will file a lien against your property. They will then execute on that lien, forcing the house to sale. The government has never taken ownership of it. They just make you sell the house. Just like if I executed a lien on your property, or if the bank executes a lien, like if you take a mortgage, you already own the land. You take a mortgage out, using the property as the security for the mortgage. In some states, you'd have to execute a deed with it. In other states, you wouldn't. But let's just keep this kind of vague. The bank doesn't necessarily take deed ownership of the property, but they have a lien on the property. And then, if you don't pay the mortgage, the bank doesn't take the property. The bank forces the property to sale. And the government will actually sell the property, and then they'll split the property up among the various creditors. So, if you think that the government is special or different in that if you accrue a debt with the government and don't pay it, it's not. It's no different than with any other private creditor. They'll also attach your wages, or they'll attach your property, or whatever. And as far as eminent domain, they have to buy it, and yeah, they do have power that like a private person wouldn't have, but that doesn't mean that you don't own the property. They have to buy it from you. And if we circle this back to the whole slavery issue, if you wanted your slave's property, you would simply take it. You don't require your slaves to pay taxes, and they get to keep the extra or the overage. You require the slaves to work for you, and then you determine what they get, if anything. So maybe you just give them food and you make them work naked, or maybe you give them food and clothing. Maybe you give them food, clothing, and shelter, whatever. But there is a difference. And if you're trying to be super, if you're trying to drill these words down to the point where they're meaningless, then the conversation is really ridiculous. Oh, if I owe a lawyer or a mechanic, it's for a service that I contracted for voluntarily. Not necessarily. You may not have contracted with the lawyer. In Texas, if you get assigned a public defender, and based on the determination that you're unable to pay for one, they will assign you one. If they then find that you are able to pay for it, then they can come after you. Or if a mechanic fixes your car and you haven't necessarily signed a contract with him for it, then he could still keep it on a mechanic's lien. I mean, subject to various proofs that he did the work for you. So, and then if you don't want to contract with the state, leave the frickin' state. Sell the property, leave the state. That's something slaves can't do. Slaves can't just divest themselves of the slave-master relationship. A slave can't simply leave and go someplace else. You're not a slave. You can literally package up your belongings and leave the country. If you think slaves could just package up their belongings and leave their master, then I don't know. There's nothing I could do at that point. You're so comical. It's not even worth discussing. And as far as the taxation is theft line of reasoning, taxation is not awesome. Nobody likes taxes. But is it theft? No, it's not theft. Theft has a legal definition. If you're going to play philosophical games and say that it's like theft because they're taking something from you against your will, well, so someone who steals from you has no obligation to you to provide you with certain things. The government takes your taxes from you, and no, you don't get to say no. But then they supply you with things. Now, you may not want those things that they supply you with, but they do supply you with things. They supply you with clean water. They supply you with food that has been checked by the USDA. They supply you with roads. They supply you with transmission lines that cross states and things like that. They supply you with police and fire. They supply you with a military. They supply you with a lot of things. Even regulations, you may disagree with them, but the government supplies you with them. So you know that if you walk into a store, they're going to have a minimum level of structural security, or there's a very good chance that store will have a minimum level of structural security so that it won't catch fire or simply collapse on you, or the aisles won't be so narrow that you wouldn't be able to exit in case of a fire. The government supplies various services. Reasonable minds can differ as to the quality or value of those services. Reasonable minds can differ as to whether or not it's worth paying the government for those services, but it is not theft unless you have a completely retarded and philosophical notion of what theft is. It's legally not theft. And again, the relationship between the government and the citizen is one where the government provides services to the citizens as a whole in exchange for the citizens as individuals to pay taxes. I've beat that horse to death now. Thank you for playing Alzheimer's Sucks, but your argument's ridiculous and very pedantic, so we're moving on. Then, oh Lord, I wasn't ready for this. Did I tell you that today's was going to be rambly? Poetic had a strange line of questioning, and I was wondering where it was going. He wanted a definition of federal property, and okay, and then we started getting into various clauses of the Constitution, and that was weird. And then finally, he sent me to this gal right here, KrisAnne Hall. And KrisAnne Hall, she is an attorney. Now, speaking of attorneys, in every legal action, and I say every using hashtag not all, but in legal actions, there are typically attorneys on both sides of the argument. One side typically loses, the other side typically wins. Now, there are situations where one side partially wins and partially loses, and the other side does the same. But typically one side wins and the other side loses, which means that generally speaking, half the time, lawyers are wrong. So if you're going to do an appeal to authority, I don't know that she necessarily does an appeal to authority. I couldn't watch too much. I only watched to where she said that the only way that the federal government can own property is Article 1, Section 8, Clause 17. But she is wrong in her understanding, and that's not something new and exciting. There have been other attorneys who have been wrong. I've been wrong from time to time. My understanding has grown since I have been an attorney, which hasn't been terribly long. But even as an attorney, so just dealing with California, there are a lot of statutes in California, and there's ever-evolving case law on each part of those statutes, and that's just California. Then you tack on federal statutes. Go down to your local library, and just look at the shelves that have Westlaw, California codes, or whatever your state is. There is a ton of them. There is going to be a very large 1 or 2 bookshelves full, full 6 or 7 foot high bookshelves that are 4 to 5 feet wide. It's huge. There's an enormous amount, and that's just California's statutes. That's not all the cases. There will be aisles and aisles of books just jammed full of cases that are continually coming out, and not every single case is published. And that's just the California codes. There's even more federal. So no attorney is going to know everything. Now, this gal spends all of her time talking about the Constitution. So one would expect that she would be right. However, we always want to go back to our fundamental understanding that if your beliefs don't conform to reality, then you need to conform your beliefs to reality. If you expect something to happen based on your beliefs and that doesn't happen, then you need to conform your belief to reality. If you think if you drop a pen, it's going to go up, and you drop the pen and it goes down, then you need to believe that gravity does in fact work. And that's where she's falling down. She has a very silly argument. I mean, if Snopes has broken down your argument and debunked it, and it has, then you know there's an issue. But her fundamental point is that the federal government is only authorized to own property under Article 1, Section 8, Clause 17, right here. To exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square as may be by cession of particular states and the acceptance of Congress become a seat of government in the United States, and to exercise like authority over all places purchased by the consent of the legislature of the state in which the same shall be, for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. Okay. So there's two parts to this. So they get to exercise exclusive legislation over all the land that was ceded by particular states to form the District of Columbia. Congratulations. And to exercise like authority, so Congress gets authority over all federal property purchased in whatever states, if they purchase it, in which the same shall be for the erection of forts, magazines, arsenals, dockyards, and other needful buildings. So the federal government can, from this very section, own forts, magazines, arsenals, dockyards, and other needful buildings. What are other needful buildings? That's anything they need. But the Congress hasn't really relied on this. They just rely on the necessary and proper. This is section 18. It's not enumerated, but whatever. To make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States, or in any department or officer thereof. So the necessary and proper clause has for a long time been the way that the federal government gets to own property. This is United States v. Gettysburg Electric Railroad Company. This is an eminent domain action where Congress took property from Gettysburg Electric Railway Company in order to make the cemetery, Gettysburg Cemetery. And they called it necessary and appropriate in here. Necessary and appropriate. Having such powers, it has such other and implied ones as are necessary and appropriate for the purposes of carrying the government expressly given into effect. They call it slightly different, but that's necessary and proper. So there you go. It is long settled. There's no good argument that the government can't own property. In fact, in the Constitution, so they get to establish post offices and roads. That would be you have to own property to establish a post office on it. Armies and navies, obviously, they get to build naval yards and army posts, but then they get to That's right. It's Article 4. I'm sorry. Article 5. Article 4. And then it is section... Congress shall have the power to dispose of and make all needful rules and regulations regarding the territory or other property belonging to the United States. And nothing in this Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. So even in Article 4, Section 3, they get to make rules and regulations respecting the territory or other property belonging to the United States. It's if it belongs to the United States, that they own the property, right? So her idea of what the Constitution says doesn't match up with the rest of the Constitution. The U.S. Supreme Court has already determined, they determined a long time ago. I'm not even sure if this was the earliest decision. This is the earliest one that contained that kind of language. So, I mean, the U.S. government probably did own property prior to 1896. Maybe no one just sued on it. But that said, attorneys can be wrong. Speaking of attorneys, this is Vernon E. Peltz. He is I guess maybe he still is an attorney. He is suspended right now for another, month? He is the third of the three stooges. And he got his little criminal trespassing third degree in Tucson for filming in the courtroom. Attorneys can be wrong. This is State of Arizona v. Vernon Edward Peltz. This is an Arizona Court of Appeals decision. It is a rather lengthy one. The long and the short of it is that Mr. Peltz is an alcoholic, and Mr. Peltz drinks and drives. And Mr. Peltz drove drunkenly with his mother in the car. He swerved, crossed over oncoming traffic on the highway, and ended up crashing his car on the side of the road. He was injured in that accident. His mother, his poor mother, who has dementia, was also injured. She had a fractured spine, she had a bruised spleen, and she had a fractured orbital socket. I believe the orbital socket would be the eye socket, but So she got really hurt in it. The state had him dead to rights. He was drunk, so maybe that came into play on it, but he talked very loudly. First of all, he confessed to the officer that he had been drinking. And if you talk to an attorney, one would assume an attorney would know you don't talk to the police. If you are suspected of committing a crime, like, for example, drunk driving, you don't admit to the police that you had a couple drinks. You also don't talk loudly on your cell phone in front of the police officer about having had drinks later on. And then when the police officer gets a blood sample and it's 0.142, you don't get to suppress that evidence because, well, various reasons. Anyway, in this case, you could read it. The Court of Appeals just really poops all over Mr. Peltz. Peltz does not contend there was insufficient evidence to support his conviction, but substantial disfigurement. Accordingly, we do not address the issue. There's lots of things where he just did a very poor job in pursuing the Peltz does not re-urge his argument with respect to Article 2, Section 8. We therefore deem any such argument waived. He doesn't do a very good job of actually appealing this. Peltz also challenged the constitutionality of blah, blah. However, he does not raise these arguments on appeal. I'm not going to say he's a good lawyer. He may have been a good lawyer at some point in time. You could look up his ratings. He has had 1 5-star rating. He's had a lot of low star ratings. So, and so those ratings aren't necessarily going to be accurate, because if a client has a particularly terrible case and you do a good job for the client may still lose simply because the client had a terrible case. And that's not your fault as a lawyer. There's only so much you can do. There's no word magic that you can do to make a losing case into a winning case. Maybe you can mitigate some of the effects of it, but there's just not a whole lot you can do. There are other incidents where Mr. Peltz was arrested for assault. Yeah, he was given probation for assault. He removed a speed bump from an easement on his Catalina neighborhood in March and allegedly assaulted a neighbor who happened to be a police officer. He got arrested for that. Apparently he was dragging the guy on the hood of his truck. Castle had to jump on the hood of the truck to keep from getting dragged away. Yeah, and then Mr. Peltz has other various offenses on his record, typically minor. He did have a problem with alcohol. Apparently, he allegedly has been sober for some time. Well, sober from alcohol. He is apparently a member of the 420 Club. You can guess what they do. Well, he was suspended for 2 years because he failed to notify the Arizona State Bar of his felony. And he continued to claim the mother was the car driver. I had pulled up at one point in time, I pulled up the state Supreme Court decision on him, but I don't have that right now. And I told you this was going to be rambly, but it's already been too rambly. So the state bar in this memorandum said he was collaterally stopped from arguing his mother was the person driving the car that resulted in his felony conviction. Respondent continues to assert that his mother was the person driving the car, not him. Respondent is precluded from using this as his defense, as he was convicted of driving the car and injuring his mother after a criminal trial. Mr. Peltz admits alcohol played a part in his felony conviction, and if he had not been drinking, his mother would not have been driving. His mother wasn't driving. Prior to his conviction, he swore he was drinking alcohol daily. He testified he has not been an alcoholic, or he's not had an alcoholic drink since he was placed on probation, and it has made him realize he was previously abusing alcohol. Whether or not he is sober now, I don't know. But my point with this is that attorneys can be wrong. And if you go on to any state bar website, you will find lots and lots of attorneys that have been disciplined for misappropriating funds, for failing to maintain attorney-client privilege, for failing to report felonies, etc., etc., etc. And a really good example, this is Doazic. I don't know how he pronounces it. It's a little dry. He's pretty dry. But I guess I am too. So he goes over these. Hat J is Heather Ann Tucci Giraffe. She used to be an attorney in Washington, and she's batshit crazy. She is, and she's a terrible attorney, and she's giving people terrible advice, and I think she just got convicted. I think she got convicted. She ended up basically admitting that they were running a scam. So, yeah. So if you want to listen to these Hat J trial highlights. Oh, there will be a link to this first one here. There's a bunch of them. They are long. I listen to them while I'm driving and stuff like that, but your mileage may vary. But there are some really crazy attorneys out there, and this gal, I don't know that she's crazy, but she is uninformed or misinformed on the Constitution, insofar at least as it says what the federal government can or can't own in terms of property. So that's it. Thanks for watching. Have a great morning.